Hello everyone. Good evening. Can we all hear me? Good evening. Can we all hear me?
Yes,
Good
I
evening, sir.
can.
Yes, I can hear you.
Good evening, everyone, once again, and welcome to the Gypsy Mentorship and Internship Program, week three of our mentorship of the IP class, week three of the IP class. And so far, it has been interesting going through week one, week two, and now we are in week three of the Gypsy Mentorship and Internship Program. And I'm sure it has been an interesting journey so far for you all that have been following. So not to waste any time, we'll be starting off with class as soon as possible. We want to try and see how best we can finish in good time. Right. We have a lineup of mentors scheduled for this class. And I can see one of our mentors is already here with us in the session. So I'll quickly be running through their profile. So just to introduce them. So our first mentor that we're expecting in class is not yet here, but hopefully he'll be joining us shortly. Is Mr. Folarinwa Aluko. Folarinwa Aluko is a legal practitioner and partner in the firm of Truman Rockwood Solicitors, where he provides advisory and consultancy services to companies and a wide range of creators, users, and startups. Folarin is a director of the Intellectual Property Institute Nigeria. He is the chairman board of trustees of the Intellectual Property Lawyers Association Nigeria. Folarin is a member board of trustees of the Sports Lawyer Association Nigeria, as well as a member of the board of the Nigerian Digital Chambers of Commerce. Mr. Aluko is also a board member of the Songwriters Association of Nigeria with a background in ICT hardware and digital forensics. Folarin has led legal teams to champion consequential strategic impact public interest litigation in the IP space since 2012. Folarin is a consulting mediator with um, commercial intermediates and ADR firm based in Lagos and Abuja. Folarin is a consulting mediator. Sorry, he's a consulting mediator with commercial intermediates and an ADR firm based in Lagos, Nigeria. He's a thought leader in the Nigerian innovation, technology, intellectual property, and entertainment space. Mr. Folarin is no stranger to us. At least I think he was here for the first session, and we look forward to having him in today's class also. Another mentor that we are not, that is not strange to us that is already in the session is Mr. Max Ikombe. Thank you so much, sir, for joining. We are happy to have you in class. Mr. Max Ikombe is the founder slash principal of Ever Law Associates. He works extensively in the field of arbitration, ICT, technology law, and intellectual property. Intellectual property. Max is a facilitator on the annual Information Technology and the Law course of the Nigerian Institute of Advanced Legal Studies since 2016. He has trained in advanced intellectual property courses at the World Intellectual Property Organization Academy, and he is an accredited agent of the Nigerian Trademark and Patents Registry and has conducted IP registration business there since 2010. Thank you so much, sir, for joining in for today's session. We are happy to have you in class. Our third mentor for today, another mentor that we are no stranger to, is Mr. Sand Umbakalu. Mr. Sand is an international development expert with over 15 years of experience in implementing projects related to geographic indications, international trades and investments, trade policy, research, policy reforms, market access, monitoring and evaluation, capacity building, market linkage, and value chains. He served as the lead technical consultant for the African Intellectual Property and Innovation Afri, Afri, AFIP project, which is funded by the European Union and the European Union Intellectual Property Office. SAND plays a crucial role in assisting the Nigerian government in establishing a robust framework for the protection and promotion of geographic indication Additionally, he is the chair of the organizing committee of the All Africa Intellectual Property Summit and has led several other development projects in Nigeria and across Africa. Currently, Sand is the executive director of the African International Trade and Commercial Research and is pursuing a PhD at the University of Cape Town in South Africa. Mr. Sand is not yet here with us, but hopefully he'll be joining us shortly. Thank you so much, sir, for everything that you do for us. I think our last but not least of our mentors for today that we are expecting in class is Miss Rita Amuri Chinda. Miss Rita, I will not be reading all of our flyers, all of her profile, because of how lengthy it is, but I'll just be reading quite a major part of it. So Miss Rita Amuri Chinda is a distinguished lecturer at the Rivers State University and an expert in intellectual property, IP consulting. She currently serves as the IP consultant for IGA Nigeria Limited, providing valuable guidance on commercializing and monetizing Lagos State culture, tourism, and heritage. In her role as a heritage consultant for the Lagos State government, she offered legal advice on leveraging the state's intangible assets. Rita holds a master's degree in intellectual property and information technology. She which she earned with honors from the University of Derby in the United Kingdom. She is also the host of the only sub-Saharan and popular podcast called IP Series, where she engages in insightful discussion on the latest IP issues and developments worldwide. The podcast had garnered a significant following with 128 episodes published on Spotify for podcasters, Spotify, um, Apple Podcasts, Amazon Music, YouTube, and other platforms. Additionally, she has authored 25 blog posts and continues to produce engaging content on Subtrack. Throughout her career, Rita has actively contributed to various organizations and initiatives. Notably, she played a vital role in drafting the Rivers State ICT policy as a valued member of the team. She has also served as a judge for the prestigious Adasva Vas Alloy essay competition on privacy data protection for 5 consecutive years from 2019 to 2023. Recognized for her expertise, she has recently featured in the BBC Gist Nigeria program on Channels TV. Rita is currently a member of the working group responsible for drafting Nigeria Geographic Indication Law. This initiative is carried out in collaboration with the African Intellectual Property Rights and Innovation in Africa and Africa's international trade and commerce with support from the European Union. I'll be stopping here in Ms. Rita's profile and just so that we do not spend so much time on it. So once again, welcome to class. Our topic for today is IP registration, infringement, and enforcement. So far, starting from week one, we started with IP for business, and then we moved on to week two where we discussed where we discussed IP for creatives and inventors. And now we will be talking about infringements and registration, infringements, and enforcement. And we already have one of our mentors here to, to get the ground rolling or to get the floor rolling. So, Mr. Max, thank you so much, sir, for joining once again. We just want you to help break the grounds on the topic for today. I think in the next 20 to 25 minutes, if that will be possible, sir. You're welcome.
Okay, yeah, thank you very much, and good evening, everyone. Of course, kindly confirm you hear me clearly.
Yes, sir, we can hear you loud and clear.
Okay, thank you very much. So, of course, I would start by, first of all, thanking and commending the JIPC Jiipcc team for keeping this going. Let me especially single out uh, Auntie Sophie, who is always following up with me, reminding me exactly when to join the class. Thank you for the great work that you do. And of course, every other person in the Jiipcc team, the consistency, the fact that you have sustained this over the years, it's really a good thing to see. For those of us in the IP space, things are getting better. There used to be a time where IP space in Nigeria, this was like a black hole. There were really few initiatives here and there to really help a person who wanted to know more about IP to really increase his knowledge base. But programs like Jiipcc have come and they have stayed. Jiipcc has lasted the mile and is really becoming an institution. So I want to commend everybody who's behind Jiipcc. Of course, the mentees and of course my fellow mentors who are joining. I don't know if they have joined, but I commend them. Each and every one of the people they have mentioned are people that I also consider as mentors, even in my own space as well. I mean, Folarin Aluko is a man I have absolute respect for. He's somebody who, and I say this, he will try to downplay it, but it's not like I'm just saying it. It's a truth that I was not somebody who learned IP in school or early on in my practice life. So I learned it much later in practice life. But Folarin was one person who really helped to put me on the path to getting to really understand IP. Rita Anwiri is another person who I call my mentor. She would also struggle with me about it, but it's the truth. There was a time I actually started my IP journey. She had gone and done a master's abroad, came back, and I was getting frustrated. I just thought IP wasn't paying me. And I was like, this whole thing is just a waste of my time. I mean, I was really saying my IP education started maybe in like 2012, 2013. But by 2016, I was getting a little tired and just felt this thing wasn't working. It wasn't bringing any money and all of that. But Rita became somebody who had a lot of passion and enthusiasm, and that really helped me to not give up on IP. And I'm glad I did not, because I mean, I'm not yet there, but at least IP is bringing its fair share of the money, and I'm happy. I have that as part of the sources of income into my pocket. So just to say, IP is profitable business. So I'm encouraging each and every one of you to really think in action. Of course, Mr. Sandu Mbakalu is another powerhouse. I met him during the drafting and negotiation rounds for the Nigerian geographical indication law, which has really gone far. I mean, he did a powerful job in that, and he's still pushing that. And we hope very soon to have that GI law passed by the National Assembly and signed by the president. And of course, a lot of thanks for that will be to Sandu Mbakalu and his team, who have really pushed that vision. So I'm just letting you know, for the mentees, please. Everyone you see who Jiipcc is exposing you to are people that you really would need on this journey of becoming, an IP professional. And like I already mentioned, the IP field is a really good field to choose to invest some of your energy, your research, your learning, and your source of income in. It's a viable field, and it's only going to get better and better as the Nigerian economy begins to realize the necessity to have real economic activity, not just the dependence on crude oil, which has been the sustainer of our economy for so long. So I'll just give a few pointers on IP registration, infringement, and enforcement, which is the topic for today. So I like this topic because this topic actually sort of covers the roughly the full spectrum of intellectual property rights protections, starting from registration to infringement to enforcement. Of course, when we talk about IP registration, we need to understand that the reason, and for me, you would notice that every time I have the privilege of speaking here, I'm trying not to only just give you direct information in terms of on the subject matter, but always to try to help you see the broader, perspective that brings about the IP law as we know it. So the idea of IP registration, must be understood from the viewpoint that intellectual property itself, like we all know, is intangible property as opposed to tangible property. I have my phone. The way I can secure ownership of my phone is that the phone belongs to me. I keep it in my physical, personal possession. I put it in my pocket. I lock it in my bag or in my car and all of that. So I'm able to physically control the phone, and that is what shows my ownership of the phone. But because we know that IP, intellectual property, is not tangible, it's intangible property, it therefore means that securing ownership of that IP requires other kinds of measures beyond, just physical possession. So that is why registration comes into play. You also need to understand that why registration comes into play is that IP is territorial. Territorial simply means that IP operates within the geographical boundaries of a given nation and is granted protection by that nation. So registration is also the way that that nation in question signifies that they have chosen to offer protection to your IP. So that is also another way you can look at IP registration. Now, looking at registration mechanisms themselves, we need to understand that IP again is a bouquet. That means it's a number of things put together. It's not just one thing. So when we talk about IP registration, we are talking in nebulous terms. That means we are not, the word IP registration is not specific because IP itself is not one. So you can talk of trademark registration, you can talk of patent registration, you can talk of industrial design registration and geographical indications registration. In a sense, you cannot really talk of copyright registration because by now we all understand that copyright is an IP that comes into being without the necessity. That means your protection is not tied to registration. Of course, in Nigeria, there's a voluntary registration system, a deposit system operated by the Nigerian Copyright Commission where you're able to deposit a copy of your work. And while that registration is not what confers protection on you, it yet would help you, for instance, to prove ownership of the work, to prove the date the work was created and such other things. However, note that where you do an assignment of copyright, then you must register that assignment. So that is where registration becomes compulsory. So assignment simply means that an assignment in copyright happens in many contexts. So let me pause here and say also that you need to understand that copyright itself, just to say IP is a bouquet of many different rights. Copyright itself is also a bouquet of many different rights. So there are at least 6 different rights within the bundle of what we call copyright. So there's literary works, musical works, artistic works, sound recordings, audiovisual, broadcast, as well. So these are the 6 different types of right that actually make the bundle of rights we call copyright. So essentially with them, you don't need a registration. You simply need fixation. Fixation simply means that you have reduced that IP into a medium that it can be appreciated by by humans. So it could be a literary work, you write it down. It's a musical work, you write the notations down. It's a sound recording, you record it on your phone or on any other device. So you don't need registration to enjoy protection of copyright. For trademark, registration, I would say, is optional. That means you can still, in a sense, get some sort of protection for your trademark without registration. Or I would say it also that you can subsequently get protection for a trademark you have started using, even though you do not register it at inception. And when I get to patent, you'll understand why that distinction is important. So for trademark, you can start using your trademark and choose to do the trademark much later. Sometimes, for certain types of trademarks that are not distinctive enough in themselves, you might need to have used them for a while and provide evidence that over time, through use, that trademark has become distinctive. Distinctive means that that trademark has become associated with your own goods or services in a way that it now serves the function of a source indicator. Source indicator means that that trademark, that word, that logo, or that design has become such that it lets people know that this product is coming from this particular organization or company or enterprise. That's what it means by source identifier. So for certain trademarks under the Nigerian Trademarks Act, you cannot even register them right away. Of course, if you do not register your trademark, you can still get some measure of protection under the law of passing off, which is usually not the best. So registering your trademark is advisable. Now, getting to patents, this is where it gets interesting. We mentioned that in copyright, you do not need registration. We said in trademark, registration is sort of optional. But in patents, registration is mandatory. No protection without registration. So if you own a patent and you go ahead to start disclosing that patent to people, for instance, you begin to demonstrate it, to people and or produce it into or make it into a product and you start selling it, you will lose the right to register that patent. That means your work falls into the public domain and anybody can use it. You can never register a patent on it anymore. So why this is particularly important, and why as an IP professional you must know this, is that particularly if you work with startups, startups are always looking for funding. So they are always going around trying to pitch their ideas to people. And in the course of doing that, they may reveal some of that confidential information that makes up part of their patent. So the standard advice is that the way to ensure that your work doesn't fall into the public domain, in terms of so that you can still register as a patent subsequently, is to ensure that you use a non-disclosure agreement when you disclose your patent work to third parties, to ensure that you still keep that confidentiality. Of course, there are also limitations in the law. So, for instance, if you displayed your patent work at certain kinds of forum, like educational trade fairs and those kinds of forums, you have, I think, 6 months, I believe also, I'm not too sure exactly what time, but I think a year or 6 months, within which you still have some measure of protection. But what this just simply means is that when it comes to registration, what I want to take away is that with copyright, you do not need registration, even though you can do voluntary deposit. With trademarks, it is not mandatory, but it is highly advisable you get registration. With patent, you must get registration. So, and you must do it early on before you do make any disclosure of your product. So that's just broadly the spectrum of registration. How am I doing for time? I want to make sure I don't overshoot time. So would it be good if I finish by how many more minutes do I have?
Sir, you can finish by 7, sir.
Okay, thank you very much. Yeah, that's very generous of you. Thank you. So I'd rush to do that and maybe try and finish a little bit earlier, so we leave enough time for the mentees to also get into their presentations, which I've seen a snippet of, and I think they are quite interesting. So we now move on to infringement. So of course, after you have registered your intellectual property, the whole idea of registering your intellectual property is to give you protection, to ensure that nobody else is able to appropriate, nobody is able to take the benefits that flow from your work, because you're the one who sweated to create that intellectual property. You don't want another person to just take the benefit of that without your permission. So that's what infringement is all about. So infringement is where a third party does any action in relation to your intellectual property that is an exclusive right that belongs to you, and it does it without your permission. So in practical sense, it can be a whole range of things. Well, like I told you, whenever I talk about IP infringement, just like I said, IP registration is a nebulous term. It means that it's a bouquet, it's a whole basket of things. So it's not specific, because there's copyright infringement, and even within copyright, the actions that amount to an infringement of a broadcast right, for instance, is different from what amounts to infringement of a literary work. So you must understand infringement from the context of the particular IP you are dealing with. Same thing with trademarks, same thing with patents and industrial designs. They all have particular things that if you do will amount to an infringement. But the bottom line of it all is that infringement simply means that somebody else is making use of your IP and getting benefit from it that should have come to you. And you can imagine what that is. But like I always tell people, when you think of IP infringement, do not only think of the money that you are losing, because the first thing you lose when somebody infringes on your intellectual property is that you are losing money. Because if I, for instance, sell bottled water under a brand called Rosie, for instance, the whole idea is that people have come to know that my bottled water is high quality. So anywhere they see the word Rosie or my logo, if I have a unique logo, they say, oh, that water is coming from that company that produces good quality water, because I see the word Rosie there, and Rosie is the name of their product, which of course functions as a source identifier and therefore is a trademark. So what it means is that every time somebody is going to purchase Rosie water and he's diverted to buy water that somebody else is passing off as Rosie water, so somebody else goes to steal my logo and my name Rosie and puts it on another bottle of water, it therefore means that if that sale is made, that money should have come to me, but somebody else is taking that, the infringer is taking that money. So you can see that at that level, the infringer has cheated me. So let's assume my bottle of water goes for 200 naira. That 200 naira was supposed to come to me has technically been stolen by that infringer. Now, that is bad enough, and that is what we mostly think of when we think of infringement. But infringement has greater ramifications than just that surface issue of somebody stealing your revenue. There's what we call tarnishment. Tarnishment simply means that a person is now lowering the quality of your trademark. Like I mentioned earlier, the reason why we buy particular products is because we associate them with high quality. So, for instance, who are Apple fans now, we don't want to use any phone but an iPhone because they believe that iPhone is high quality and comes from a company, Apple company, that pays attention to detail and produces a good product. But what happens is that when I allow an infringer to start producing my bottled water, the question you ask yourself is that why does an infringer not go to create his own brand and build it up over time? It is many reasons. Number one, the infringer doesn't want to put the hard work of building a brand, doing advertisement, doing quality control, doing all the hard work that it takes to produce a good product. He just wants to make money off someone else. So already that tells you that the mindset of an infringer is a mindset of low quality. So what he's like to happen is that whereas my rosy water, I take my time to do triple filtration, I pass it through ultraviolet light, I do everything to make sure the water that comes out is high quality. But the infringer might just go to a tap, put the tap water in the bottle, seal it up, put my logo Rosie and go and sell it. So what happens is that when that infringing product gets on the shelf, two things happen to me. And the second one is what I'm pointing attention to. The first, I already mentioned that I'm losing the 200 naira on that bottle of water. But the second is that the person drinks the water and announces that, this rosy water now has taste. It's no longer good quality like it used to be. The person is now disillusioned and says, rosy water has lost quality. So you can say that my brand has now lost reputation. So beyond losing that 200 naira now, that person is going to tell his relatives, rosy water is no longer good, or let's buy another bottle of water. So apart from the 200 naira I've lost, imagine how much more I will lose as word of mouth begins to pass that rosy water has lost its quality. So I always tell people that this second part of infringement is usually more dangerous than the first part, than the direct loss of revenue. The fact that your brand is going to lose its reputation over time, and is even more dangerous than the primary issue of the infringement. So lastly, let me move on quickly to enforcement. So of course, enforcement is the consummation of the whole journey of IP registration, monitoring your IP, detecting when there's infringement. You want to enforce it. So it simply means that you want to ensure that your intellectual property is respected and that nobody is infringing on your intellectual property without your permission. So enforcement can take a number of variety of ways. And I won't go into the specifics now because I already know that we'll discuss that in your presentation and in the questions that come afterwards. But what I just want to point your attention to is that when it comes to IP enforcement, of course, there are a number of ways you can get that done. But one of the interesting parts about IP enforcement using the courts is the issue of jurisdiction. So it's something that sounds simple enough, but there are still a lot of unsettled issues around which court actually has jurisdiction in an IP infringement case. Now, one of the things I like to tell people is that just the same thing I said about IP registration and IP infringement, you are just talking about a nebulous term that is a basket of many things. Same thing also with the jurisdiction for intellectual property enforcement. The courts that have jurisdiction is not something you just pull a blanket and say that all intellectual property matters go to the Federal High Court. You have to look at the particular intellectual property involved in question. So one question that has been quite troublesome for a while is which court has jurisdiction over parking of claims. We know that when the trademark is registered and all, definitely the Federal High Court has exclusive jurisdiction. You cannot go to any other court apart from the Federal High Court. But the question now becomes for things like passing off, which court has jurisdiction? For things like a franchise agreement that involves the licensing of trademarks, of patents, of copyrights and many other bundle of rights, which court has jurisdiction? Because on the surface, a breach of a franchise agreement is a breach of contract, should normally go to a regular high court. But because embedded in that dispute are issues of trademark infringement, patent infringement, that should go to the Federal High Court. So it's still a dicey question. It's not, there's no hard and fast answer to that question, but it now depends on the type of claim that the party is making. So the party is saying this dispute arose because my trademark right was infringed and it's registered trademark, then that becomes a trademark claim that should go to the Federal High Court. But if the substance of the claim is simply a contractual dispute and the intellectual property element is just collateral to that, then you might think of going to the High Court. Even though sometimes I advise people that in those kinds of cases, sometimes it's best to go to the Federal High Court because we have decisions that say that both the Federal High Court and the State High Court have concurrent jurisdiction on those matters. But it's not a question that has a one size fits all answer. It's something you have to handle and take on a case by case basis. So at this point, I think I've exhausted my time and I would make it a hard stop at this point. I look forward to the engagements during your presentation and the Q&A that comes after. Thank you all for listening, and I look forward to listening to your own presentations and that of the other mentors who are on the call. I already see Rita Chinda on the call. I'm looking forward to our presentation as well. Thank you,
All right.
and back to you.
Thank you so much, Mr. Max, for that very insightful and practical session detailing what IP registration, infringements, and enforcement is all about. Yes, so we have all our mentors on the call right about now, but we'll be taking it on a step-by-step basis, moving from one mentor to the other. So our next mentor that we will be getting to hear from in today's session is the wonderful Miss Rita Amuri Chinda. Please, ma, we would like to also hear from you in the next, let's say, 15 minutes, based off of what you have prepared for us in the session, your discourse for today. You're welcome, ma.
Um, Hi everyone, good evening.
Yes, good evening, ma.
Can you guys hear me?
Yes, ma, we
I
can
don't know
hear
if
you
my
loud
mic
and
is
clear.
bad. Okay, so
This meeting is being recorded.
I also have another meeting that is ongoing, but let me just sorry about that. Okay, so good evening once again. Mentor of Life, Max Ikome, thank you so much for the brief introduction to the topic, which is IP registration, enforcement, and infringement. Just like how Max had previously stated, all of the IPs all have their basic requirement when it comes to IP protection. And it's from that protection that you now determine who an author is and who the owner of an IP work is. And then decide on whether I think I'm frozen. Why is that even happening? Okay, great. And then decide on what to do in the event of a dispute. So I'm just going to focus on the dispute resolution aspect that requires, that basically marries infringement and IP enforcement. So in the event of a dispute, whether it's a copyright dispute or trademark, patent, industrial design, whatever type of dispute it is, it's very important that you are clear on what the dispute is and then decide on the strategy that you want to embark. I'd like to tell people and my students or my clients that in the event of a dispute, instead of opting to go to court, it's more appropriate for you to first do your investigation and discover whether there's actually an infringement. If it is there, you now decide whether the infringement is either a direct infringement or a contributory infringement, whereby anyone who has infringed of a work may have either done that intentionally or unintentionally. When you move on from there, you then decide on the mechanism to actually adopt. Are you actually going to um, trigger a takedown proceeding if it's an online related dispute, or are you going to actually sue? If yes, will you be going to court? If no, would you be submitting to an alternative dispute resolution mechanism such as mediation or arbitration? I like to also tell people that when you consider this kind of IP um, enforcement mechanism or dispute resolution mechanism, you have to decide on whether your dispute in question is commercial, is a huge commercial transaction. If it's not a huge commercial transaction, it's best that you opt to mediate rather than arbitrate. You may want to also explore administrative mechanisms such as the dispute resolution panel, as we have under the Copyright Act. I think that's under Section 19, which clearly states what kind of dispute can be resolved through the panel. You also need to consider if it's like a trademark dispute, are you opposing? If you are, do you have the right standing to actually do that? If you do not have, what is your next alternative? So all of that have to be taken into consideration in the event of an infringement. And for enforcement, if it's a cross-border related dispute, you have to engage the customs, or do you have to look for someone within that jurisdiction that can help you with regulatory compliance in terms of reaching out to the right agency to help you enforce border measures and stuff like that? So those are kind of some of the conversations that you would need to have and consider. One thing again that I also like to tell my students or clients or anyone that I engage in terms of IP is that you need to also consider your jurisdictional provision in terms of how enforcement should go, because as we know, IP is territorial in nature. If it's Nigeria, we should take note of the regulatory compliance or regulatory framework rather. If it's within Africa, what are the available regulatory framework? I think for one that I think Nigeria is even more particular about should be the after IP protocol and the after dispute resolution protocol. Those you also have to look at what provisions have been set in place. I think also that in relation to the topic, we also need to look at how authors, especially those in the creative sector, have been pushing back in terms of the AI IP conversation. So while you're thinking about your topic, you also have to look at it from the emerging area and products or technologies that may not have come into place. Are your laws well placed and positioned to protect you? How many of our creators are even bothered in terms of whether any AI company or AI model is being used to scrape and train these AI tools are available? So if you really want to understand how IP in digital age works, I think following these AI conversations with the Westerners in terms of determining authorship and ownership and rights, and whether there's a need to actually explore commercial routes in terms of licensing to generate revenues for these IP owners. Also, if you eventually go into contract in terms of trying to monetize or actually exploit your work, you also need to be clear on how you will deal with infringement issues, on how you will deal with the type of IP available. If you have like a confidential information breach, what are the preventive or proactive measures you've put in place, or this resolution that you put in place to say if this happens, this is what parties are actually going to consider in that event. You also need to look at the pros and cons of your enforcement strategy. Will it make you spend more money? Will it also sever the relationship you have with the party in question? You also need to look at infringement from the aspect where the infringement is coming from the users and not third parties who want to actually make money. If a user, so say you have a fan base or a community and someone decides to actually make profit or create fan works out of your product, do you go right out to actually sue the person, or do you send a cease and desist letter to the effect of trying to like scare the person? So I had a privilege of being part of a dispute that occurred last month. And interestingly, the person in question happened to be a student in my school, where one of the big artists had to read their lawyer write to them asking the student to stop creating merchandise with their name, image, and likeness. And he was shocked as to why he had to receive that, especially because he was a diehard fan. So how do you deal with such infringement from community members? Do you encourage that infringement, or do you go into a collaboration? Because to him, what he wants at the end of the day is a collaboration. So sometimes in IP infringement, when you're trying to resolve that dispute, you also have to reach out to the other party to find out if they had ulterior motive or there's any other thing they actually want from it. Because at the end of the day, it's all about encouraging creativity within these sectors. And as you know, And as you know, IP has its tentacles in other industries. So if, for instance, you're in the pharmaceutical industry and you have created a product that will actually revolutionize the sector that that product has been created, you set your fee for that product at a very high rate, or do you actually reach out to the government to say we are willing to opt into like a compulsory license agreement with you to give this product out, or do you just put it um into the public domain? So there's something interesting that I had that conversation with my student last week when we were discussing alternative corporate schemes, whereby you have you have certain requirement for using copyrighted work that will not lead to an infringement. So you consider things like a Creative Commons license or an open source work, or a I think it's called a zero public domain license, whereby you intentionally put that product out there for people to actually use it, as long as they acknowledge you at the end of the day. So you find out that all of these IPs, while they are unique in their nature, they also have their terms of use when it comes to how you actually use it, whether it's for commercial purpose or non-commercial purpose. If it's for commercial purpose, what does the law provide in terms of how to use? And how do you then differentiate between that thin line between when a use is from an inspiration or when a use is an infringement? If you look at the digital era where everyone is online, or was assumed that the world has gone global and it's now become a small village, how do you then deal with online related disputes that are not happening within your jurisdiction but from other jurisdictions? Do you trigger the treaties that should or already exist in terms of protecting or setting some sort of guidelines on how IP in the international space should go? What is the conversation that you should be having when it comes to disputes that you may think are internationally and need some sort of enforcement mechanism? Do you collaborate with other agencies in other jurisdiction, or do you go yourself to enforce your right? So you also need to consider all of this while you're either a creative or you are an inventor in this space. What are those mechanisms I would put in place to ensure that third parties and unwarranted persons do not have access to my work? So, for instance, if you um, had the opportunity to review the Copyright Act, for works online, other than the takedown proceedings, you also have things like the technological protection measures and also rights management information, which is also known as digital rights management. So those are some of the things that you need to consider when you're talking about or discussing or researching or writing on infringement and enforcement. So I believe I will stop here and wait for your questions, but I do hope that I've been able to make sense and my contributions added more knowledge to what my mentor of life, Max, has previously told you guys. Thank you.
All right, thank you so much, Ms. Rita, for that wonderful and insightful discourse from you. All right, we really, really sincerely do appreciate your take on today's topic. So moving forward, I think we still have two mentors that are with us that would like to also hear from. We have Mr. Polari and also Mr. Sand. So I think we'll be starting with Mr. Sand, and then we'll move to Mr. Polari. Mr. Sand, we would also want to hear from you in the next 15 minutes. Thank you so much for joining. We are really, really happy to have you in today's session. Please, I would just want to hear from you on your thoughts from you on the topic for today.
Okay, so thank you very much. Good evening, everyone. Thank you, Max, for that deep and practical examples you gave during your presentation. I've gathered enough. I've also learned from what you have presented, and thank you very much, Rita. I must say this is the first time we are seeing this year. Happy New Year. I've also learned from your practical experience, sharing the real life issue when it comes to infringement. Permit me to
for my camera to be off because I'm on transit, so I don't want to turn it on. I told Sophia that I don't know if I will be able to make it, but I think where I am now, I'm a little bit stable, so I can speak and just share my thought. You know, registration, IP registration, as Max has rightly pointed out, IP itself has different aspects, fixed agreements, states different aspects. And now we're speaking in Nigerian context, and currently there's also an ongoing continental arrangement, which for me comes as an interesting outlook we're trying to present ourselves. You see, when we, and this might not mean anything to a lot of people, but I'm proud that we, or I am experiencing where Africans are proud of who they are. This is not part of my presentation, but I'll just go to my presentation and I'll just speak to that. You know, we have trademark, we have marks. Everybody know what marks is. But you know, under AFCFTA, what I've discovered is that Africans wants to be known as Africa. So there is this slight alphabet, you know, that is representing who we are as Africans. So marks is AFMAC. So you see, they talk about industrial marks, they put AF, they put copyright, they put AF copyright. So AF, you know that this is an African stuff. That's just by the way anyway. So let me speak to what I've been asked to talk on today: IP registration, infringement, and enforcement. As I've said several times, my interest in IP itself is not more of the legal aspect. My interest in IP is the aspect of the commercial aspect and the good people's idea brings to the world. What do I mean by commercial aspect, the trade aspect? I believe, and that is why everything I do on IP is right. I believe that the world, it is what it is. The good we express in the world, the system, now we can communicate with different people from different parts of the world, was because someone had an idea, brought it to the fore, and was rewarded because he was able to practicalize his idea and was able to invest more to make the world a better place. So when we talk about IP registration, as Mark has rightly pointed out, we have the copyright, we have the trademark, we have the patent and patent design. We have plant variety, we have traditional knowledge, we have geographical indication. So these are different aspects of IP. So if you want to register your idea, and some are not even ideas, some are like, for example, geographical indication is already given to you, it's not more your idea. So it is already something existing. So you just want to just appropriate it to you because of where you are from or where you are located. And that one is not just you, it's about the community. So the community gives back. So as a business person, as a person, when I think about IP registration, I'm looking at it from the perspective that what good is your idea? What good is your client idea to the community, to the world, and to themselves? So if it is an idea that you know have a prospect for people to benefit from, so you then need to then invest into it by first of all taking one step, saying, okay, I have an idea, so I have to then register it. So now you are investing into it so that it will give you an opportunity to be able to grow that idea to become something that will benefit people and also benefit you. But if it's an idea, because you can go ahead and say every idea that I have is markable, is trademarkable, then you might end up spending so much and not having much from it. So, because IP registration does not just end in IP registration. After registering your IP, your design, your patent, you also have to commercialize it. You also have to brand it. So that branding in terms of commercializing is to be that. So it will come to the infringement part. I will speak more to that when you know your idea has gotten to that level where it becomes known to the market and people wants to free ride your idea, and what measures do you need to take? So the foundation is this: is your idea going to do any good to anybody, even yourself, before you go and invest into it? How about you doing the basic? Basic is this. How about you advising your clients? Not everybody that sings music. Not everybody don't blow with music that they sing. Say, I have this, I have that. You know, some people are singing for years. Nobody's even bothering about them copyrighting anything or even mimicking them or anything. But because there is, when you invest, when you say, okay, every music I want to, okay, you copyright it, I want to, no, you might end up just spending all your money doing something that will not benefit you or benefit your client. If that is your first thing, you have to advise. So even while it's in between, do you register first or do you start operating on your idea to start getting traction? But before you start that, you must have a consistent process, have a brand, consistent branding, consistent packaging before you start registering it. Because if you say you want to run into registration first, you end up investing into something that will not bring return to you. Why not start first before you start considering registration? The first thing you need to do is to even register a business name. If it's a business name or a brand name with TSC, having a legal document that you can then start, okay, I want to start doing business with that. Because if you do that, if you start earning, then you can then, okay, this is, people are recognizing this, my idea of making a pen that writes with water. So what do I need to do? I need to document the process of making my pen that writes with just water. So there's no need to make any chemical anymore. That's what makes it unique. Then you then go to, okay, let me trademark the brand. Then you can start investing gradually and start building up from there. Because that will then give you an ability to access funding, an ability to start allowing other people, if you want to franchise it, if it's like a food chain, for people to start investing into it, to then come in. Because I'm conscious of the last time we spent time, and it was a lot of, we dragged, I think we even used more than an hour during the late into the time. So I will just speak, I'll rounding up shortly. But I will speak on infringement. Rita pointed out something. He said a fan was creating items from someone he idols just to attract the person to him. At the same time, I was wondering, if the fan is creating an idea from someone that has created, that has brought his idea and invested into it, and it now becomes something someone can model and look up to, has he also thought it when he was selling those things, put some money together and say, or buy a gift and send to the person he has been selling his item, his IP, and say, okay, sir, I have been making some items from your name, and I'm selling and making some money because I adore you. Take this percentage. Then you can say, oh, wow, I want to collaborate with you. You can't be chopping all the money and they come after you and say, no, I'm just doing it because I'm a fan of you. Nah. There is more to that. So infringement in the African context can come in different formats. People, and I've said several times, Nollywood itself ride became popular because of piracy. People have argued that it's not really so, but truly, then when the cassette was cassette, people double music. We also cut tapes and we play these musics, and brands became known, artists became known. This year's word IP is IP and music beat the IP. I think that is what the theme is. So there'll be more presentations and discussion on the creative sector this year as it relates to IP. So, but infringement in the African context can be seen in a way. Not every infringer you can use the hammer and go after. So you should be able to look at it. That means if your brand or your client brand is gaining traction, because it costs money to even track who infringe what or who misuse your item, especially in this day of digital age. So, for example, if someone, digital piracy, someone downloads your music, how do you know someone downloads your music? How do you know someone made an ebook? The other day, there's a book being sold in, I stay in Abuja, by the way, along the Federal Secretariat. And I know this book was, since the writer, this is like copyrighted book, and this is like UTC printed copy. But the guy that the author lives in the US, he doesn't know who is selling his book here. But because if he has to know, he has to invest into it. But however, if someone reads it and understands and can write a piece about it, so the person is infringing on someone's idea, but at the same time is creating publicity for that person. So you have to look at it from that perspective. The only danger about this aspect of infringement is when someone does counterfeiting that will harm people, or the brand, as Max said, so the brand, a brand that is already known, or make it in a way whereby the market a known product. That is the aspect that one has to, and that's why it's not that I'm promoting infringement. I'm only saying that in the African context, when your first approach about going after people that are using your idea is not about using legal action, but it's about engaging them and knowing the intent. However, when you know the person has a criminal intent, you can then take it a step further. But before you start doing that, before you even get all the necessary information, it costs you money. So do you have that ability to push that through as a startup business with known brand? But most known brands do that. And I think that is where, for me, I feel that is where our business membership association has to come in. So business members association should be able to offer services to small businesses to protect the IP. So for example, chambers of commerce, they don't consider this. As a member of a chamber, I feel there should be more of a proactive, where it becomes a collective, protecting small brands, protecting small SMEs, coming up, trying to make things, this aspect of who infringe what, or who takes, who copyrights what, or who create a product out from the original product. They can offer that backing because it costs money. So if you're advising clients, because for you to get the real information on who is infringing on what in this day and age, you have to have a lot of mechanisms put in place. So following who infringe on your product might not be the first option, but you can also look at it as anybody that's creating my product. People do a lot of things. They are putting it out there, download for free, because they want people to reproduce, so that their product can go far. However, just a little bit of dovetailing into the enforcement component. There's something I discovered lately is about copyright at 2022 that was signed into law. I think it was sometime in March 2023. In the whole IP system in Nigeria, copyright is the more up to date, outside the plant variety act that was just recently created. But I think copyright, they're doing well, maybe because they are commissioned, and maybe that's why people are advocating for us to have a central industrial system so that we'll be up to date about some of these evolving things. For under enforcement, Copyright Act 2022 has some provisions that made it easy for someone to enforce when their product has been infringed upon, and is especially in this digital age. For example, the definition of copy has been clear about it, saying that it includes digital reproduction, thereby reinforcing this issue of if a product is digitally reproduced and you realize it online, you can just write to NCC, they will take it up with you. Or you can even write to the platform owner saying, take down this product because I've been infringed upon, and you can follow it. And by the way, I got some questions, and this my little research about who can you sue anonymous someone. You can sue even outside your territory. But I'm also of the view, do you want to start suing people or going after people at what level? Do you want to sue someone that is, so I just give an example of someone, a pirated copy of a book being sued in Abuja and the author is in the US. Do you want to start flying to Nigeria to sue someone that prints, maybe they print it in volume, but there are other venues you can use to get that sorted. But under enforcement, I feel in the IP ecosystem in Africa, in Nigeria, copyright is the one that is really up to date, that have addressed some things in terms of taking into consideration the current system that we operate in, the evolving digital system that we have. Because it's also in the art, it also promotes safeguarding content through encrypting the content. So that means like software and the rest of it, you can encrypt it to protect it. So anybody that hack into it, you know that this person has a criminal intent, not just because the person wants to just play with it or is a fan. And it has also empowered NCC for investigation, to investigate and persecute whoever is found infringing on other people's rights using on the digital space. That's why these days, whatever you post online, be it on X or WhatsApp, one has to be careful. And even the only thing I don't know is that if they can really enforce it, because these days, some of us that are Christians, we go to church, we see someone sing, release his album, and the next day they are singing in church, everybody is dancing, we are giving offering. The guy that release the song is not getting anything. But maybe once in a while, because they've sang the song so much, they will invite the guy during anniversary to come and sing and give person honorarium. Maybe that's the way in African context, the person is benefiting from them. But in summary, I feel this is a topic that is good that we look into, and we have different perspective to this. IP itself is the way to go for a business to be sustained and for a business to retain its bring good return to the owner, and as well as see that the business go global. As I've said earlier on, my interest in IP is the commercial part. But why that commercial part is that what good is it doing to the world, and what good is it going to do to the person? So if you look at it from that perspective, so that means that whatever you want to register as whatever IP aspect of IP you want to register your product, maybe it's design, you should look at it from that. You should have a business plan, business mind to it. And that business strategy is also look at, even if someone infringed on it, what is it going to benefit me or is it going to work against me? And in terms of enforcement, how much do I want to spend to enforce my rights? Is there other mechanism, arbitration or administrative mechanism that we have to use? Which of course, I don't want to repeat what colleagues have stated in the past. But yeah, so I would, the question that was shared, I don't know if it was now to respond to them, but anyway, I'm here to listen to the mentees and as well as give my perspective, not from a legal point of view, but from a businessman point of view. But I think that is the whole essence of IP. Thank you very much.
Thank you so much, Mr. Sang. for another very insightful discourse on the topic for today. Well done. Thank you so much, sir. We'll be taking questions at the end, towards the end of the session. But before we go to questions, we would be having Mr. Polarin give also a very quick discourse on the topic, and then we'll be taking presentations from the mentees. Please, I would like to ask the mentees that if it's going to be possible, we want to take your presentation very quickly, right? 7 minutes for each team. So please try and keep to time when you are called up for presentation. For Mr. Polarin, sir, the floor is yours for your discussing today's topic.
Good evening, everyone. It's indeed a pleasure to be here. Thanks for a very interesting conversation thus far. I think a lot has been said, and I must commend everyone else, all the fantastic presentations that have been made so far. I don't think there is much more that I can add. Everyone has spoken very well, from Max to Rita, and then Mr. Sand. I think talking about IP registration, infringement, and enforcement really speaks to the proprietary nature of intellectual property. So that's the property in intellectual property, and I think this is where we would say that these three things, registration, infringement, and enforcement, all center around the conversation of IP protection. So what is the role that the laws play in allowing individuals to protect their property that is intangible, the intangible property, and speaking about the forms of IP. I think I'll just mention, maybe highlight two things. The first thing I would like to highlight would be, there was something Max talked about, and I think Sand also kind of referenced it, and it has to do with one of the costs of infringement or counterfeiting, and that is the cost in the market cost of counterfeiting. You find that, I think, I remember a long time ago, Lagbaja famously, took a recording crew and went to the streets and recorded himself buying a pirated copy of his CD. Now, an original Lagbaja CD at the time, I think, cost about 1,000 naira or 1,500 naira, which was a lot at the time. But these pirated CDs, I think, cost about 100 naira. And as Mark said, the pirate or the counterfeiter is only interested in how do we find a product that is, marketable, that is in high demand, and then how do we use that product, sell as many copies or as many units of it, regardless of the quality of what is being sold, and what that did for someone like Lagbaja, for example, or what it does for most products in the market, is that it artificially changes the market price of that product, the market valuation of that product. So, for example, Lagbaja, let's say, for example, would sell his CD for 1,000 naira. So in the open market, he would need to sell X number of CDs at 1,000 naira each to recoup or to break even or recoup whatever investments he had made in putting that work together. And then now you have an infringer, or you have somebody who just buys a bunch of CDs or discs at maybe 50 naira or 40 naira per disc. and then, you know, prints on them, does the copies, and sells for 100 naira. So and introduces them into the market. Then you have a situation where the market has now taken Lagbaja's products at 100 naira. So the market value is 100 naira. If tomorrow Lagbaja releases another CD, the price of the infringer's price will affect how much the market will be willing to pay for Lagbaja's music. So let's assume there's no infringement the second time around. You know, because people had bought the CD at 100 naira previously, they are not likely to want to buy it at 1,000. If 1,000 naira would appear to be, you know, a huge increase or an overvaluation of that work. So it's interesting how among the other plethora of ways that, you know, infringement and piracy, you know, affects a product, it affects the market value. I think most importantly, it affects the market value of that product. And of course, it affects it in a very negative way. It's rarely ever positive. So I think that's one thing I'd like to just to emphasize. And then the other thing I would like to emphasize or to just touch on is the distinction between, you know, the intellectual property and the intellectual property laws that protects that property, you know, and then allow people to exploit and to use the intellectual property. There is, just as Max said, there is no the range of what we can consider to be intellectual property is open-ended. If we're looking back historically at the common law system, you know, the protection of monopolies were initially granted to, or at least under the current system that we use. The conversation started with literary works under the statute of, and then that has now been expanded to include several other types of works, you know, protected by copyright. But it's an open, what's it called? It's the range of what is considered to be intellectual property is actually open-ended. So I was thinking recently about, it's not a recent phenomenon. I find that I was talking to a friend of mine who said that many students in university now sell perfume oils. The sale of perfume oils is a thing now, you know, and it struck me that scents, that's the smell of scents, are actually not protected by any of the forms of intellectual property rights or any of the forms of intellectual property protection that we have today, you know, and that's quite interesting. Yes, for some certain jurisdictions allow for the registration of some scents as non-traditional trademarks, but in the general sense of it, you know, scents are not currently protected. So Creed Aventus, I could have somebody mix Creed Aventus, you know, and if it smells like it, you know, the person can sell it as Creed Aventus. I remember Designer Imposters, you know, and a few other companies that made a name for themselves by selling scents that smelled like very famous scents. You know, so I think the point here is that is to just note that the range of what we call intellectual property is very open-ended, you know, but naturally the forms of protection that the law creates, of course, will have to be, there has to be some sort of system by which the law can ascertain what type of property you have, and then how that property can be owned or who owns that property, you know, and so on and so forth. And that is how we come up with schemes of registration, deposits, you know, and so on and so forth. So, yeah, so I think those are two things or 2 points that I would like to just touch on and highlight. Thank you very much for having me. I look forward to having an interesting conversation going forward.
Thank you so much, Mr. Bolarin. We really did enjoy also another very practical. I think, it's more of a team from all the sides of our mentors, the practicality around, registration, infringements, and enforcement, how to go around it. Our mentors have done well to share, their piece of, just their own little piece within the context of the topic, giving details to how they affect the markets, and also the laws that really makes it impossible, or makes it difficult to enforce within that sense also. So we'll be moving on. Mentees, please.
May I quickly? I'm sorry, Daniel.
Yes, sir. Please, you can go on. Hello, Mr. Polarin.
Hello. Yes. Okay. I was just going to point out that somebody brought something to my attention during the week, and it was a copyright infringement notice that was served on somebody, a user who, or a Starlink subscriber. So a major studio, one of the big three studios, had sent a copyright infringement notice to a company that uses Starlink. And they had sent the notice to Starlink to say that one of your users downloaded copyright protected material. And then, of course, they made some demands from Starlink. And then Starlink informed the Nigerian company based in Nigeria to say, XYZ was downloaded, or was copyright protected material was downloaded to a computer connected to this network using our system. We have the right to do this XYZ, and so on and so forth. And it turned out that the video was torrented. The person used a BitTorrent client to download the video. So still speaking about this idea of, do you chasing infringers, single infringers, halfway across the world? Technology makes some of these things very, very easy. So the fact that, 10 years ago, it was almost impossible to think that one of the big three Hollywood movie production studios would contact a company in Nigeria, and ask them to, or raise a copyright claim against them. But we find that these things are already here. So talking about infringement and enforcement, technology plays a huge role in bridging the gap and shortening the distance among continents. So if you use... Hello?
Yes, hello, sir. We can hear you. Your volume
okay.
just...
For the volume dropped. Okay. For those who use Starlink, I would say if you download stuff, you want to be very careful, because they have records and they keep their records, and one can become liable for infringement. So thank you very much. Sorry for that. I just thought it might be a good thing to raise.
All right. Thank you so much, sir. We really do appreciate it. Thank you so much. So back to the mentees, we have two presentations from Group 1 and Group 2. So please, we would like to have that as quick as possible. Please remember it's 7 minutes for presentation. The Group 1 presenter, if you're ready, please kindly go ahead, share your slides, and let's start the presentation. Presenter for Group 1. Can we have the presenter for Group 1? Okay, not to waste any time, if Group 1 is still having issues setting up, Group 2, please can we have your presentation, and then we'll go back to Group 1.
All right, good evening, everybody.
Good evening, Fortune.
All right, Fortune Dikion, I'll be presenting on behalf of Group 2. Good evening to our mentors. I want to say a very big thank you to each of them I was privileged to learn a whole lot. The teachings were enriching. And particularly, good evening to Marita Chinda Amore. She's my lecturer in school. And I could remember the first time I saw her when she was presenting during the PPL conference, and it was very insightful. Fast forward to today, River State University now offers IP as a course. Well done, Ma. Thank you so much. All right, moving forward to today, we'll be looking at what IP enforcement. What is IP enforcement? IP enforcement simply refers to the act of taking legal action. Sorry. Okay, IP enforcement simply refers to the act of taking whether a legal action when your IP rights have been infringed upon, according to the World Intellectual Property Organization. So why is IP enforcement necessary? As we've all seen the cases presented by our mentors, there have been series of cases where your IP is being infringed upon, you lose in so much. It's just like you've created something, you worked for something, you have a wad of cash somewhere, and then you leave it open for every other person to come, take one out, you're losing. As a business, you're losing. Your brand can be polarized, and all of that. So when it comes to IP enforcement, it is very, very necessary. Just like our mentor said in the other class, IP itself is like an asset. That when it is being protected, that IP right gives your business an added advantage. So it's not a kind of thing you just, we have this law, like Nigerians, we all know that we have some of these laws. However, enforcement can become a problem. Therefore, IP enforcement is very, very necessary. So your protection doesn't just be mere on white paper. We need to give life. We need to give interpretation to these laws. So moving forward, what are the objectives of IP protection? First of all, to stop infringement of IP rights, and then to prevent further violation of your IP rights, and also to assuage the prejudice that has already been caused by that infringement. We have some case studies. Let's say, for example, the case of Google and Apple, for example, is a known brand. Sometimes you can see that even as large as some of these brands are, there are still cases of IP infringement. However, if you just leave your IP to be infringed upon without enforcement, you are the one losing. Whether as an inventor, as a creator, you're losing money, you can even lose your brand in the process. And also, it can also protect their creative works. You don't want a situation whereby your work is being, like, you're not getting the advantage, you're not getting the value for what you created. Moving forward, we also have to guarantee quality and product quality and safety. I was scrolling through the internet one time and I saw some person, they were bashing Regina Daniels for using a fake Louis Vuitton bag. Mind you, there are some persons today that they don't buy anything Gucci. Why? Because the brand has been polarized. So sometimes when you don't protect your IT as a business, as an inventor, you give room for anybody to just, make counterfeit of those your products. And we too, as consumers, we become so scared of using these products. But if in situations whereby your IP rights has been infringed upon, you actually, take a step forward to enforce your rights, consumers will have confidence and trust in your product. And also, it can also ensure fair competition in the marketplace. Moving forward, there are different ways of enforcing your IP. We have the physical option. We also have the online option. In Nigeria, for example, we have international treaties like the TRIPS agreement, the UCC, that actually acts as a mechanism to enforce some of our IP rights. For the physical enforcement options, we look at the customs and border control measures. As you can see, there are cases where that IP product can actually be seized. Let's say it is a tangible product, it can be seized. There also been cases of raids by these administrative bodies such as NAFDAC and NDLEA, and also police intervention. And when it comes to litigation and civil remedies, I know we all are aware that pursuant to section 251 sub 1F of our constitution, when you want to enforce anything that has to do with the Patent Act, because these are federal laws, the Patent Act, the Copyright Act, the jurisdiction is within that of the Federal High Court. So when you want to enforce, we all know that we have to, institutionalize these matters in the High Court. So if as an entrepreneur, a creative, you want to enforce some of your rights, you can actually go through the mechanism of the court, as provided even in some of the acts, like We have Section 46 of the Copyright Act and also Section 67 of the Trademarks Act. Then when it comes to criminal prosecution, you can actually institute, this is like the government taking over to enforce some of these IP rights where it has been infringed upon. That particular product, or maybe that's, if let's say something tangible, you can actually penalize the offenders by, putting them in prison, or you can also receive injunction. Yeah. So when it comes to remedies that are available for you, where your IP right has been infringed upon, there are lots of remedies. You can look at the remedy of injunction. You can, meet the court and, enforce your rights, probably by requesting for a mandatory injunction, a perpetual injunction, just to ensure that your rights, to stop further prevention and to ensure that your rights has been protected accordingly. You do not want a situation whereby your IP right has been infringed upon, but you cannot do anything to actually enjoy the rights that you already have. When it comes to online remedies, please help me move this slide, sorry. Can you hear me? Sorry.
Yeah, to which page?
Okay. So bringing us back to a particular case study, that was just a month ago, on the 10th of February, the NAFDAC, just like I said earlier, where there can be seizure or administrative control by some of these bodies. On the 10th of February 2025, NAFDAC actually impounded over 10 trucks of fake drugs. So you can imagine. I remember when I was a kid, then I used to be so afraid of drugs and all of that. Not really big. Then I would tell my parents, it's chalk. Anyway, it was actually because of that bitter taste. So you can imagine the number of people who don't want to take drugs anymore because they feel that some of these drugs are counterfeited. If you see this case study, this is a recent case study that happened on the 10th of February. They saw over 10 trucks. You can imagine 10 trucks in a particular market, a big market for that matter, where even most wholesalers go to buy their merchandise. That was at Onitsha market. NAFDAC uncovered the fake drugs at various shops in the market. So it's not even a situation of it was just one shop. You can see how this thing moves in segment, different shops. Another case study we have, please move this slide. Another case study we have was that of the NCC, where they confiscated over 1,492 suspected pirated books, just like one of our mentors spoke about the US writer and his products being pirated here in Nigeria. As for me, I'm a book vendor, so I sell. Most times after buying some books, you see that even some lines are faded. So imagine you're an author, you're a creative. Richie, my mother's new book she just released, Dream Counts, that has been trending. Everybody wants to have a copy. It will surprise you to know that I logged into some of the websites and they already have these books in soft copy, So some of all these things are things that the author, the creative is suffering from. So you don't just want a right that you cannot protect. You need to take a step further. Is it by administrative enforcement? Is it by the court mechanism? Whichever mechanism that is relevant for you to assuage your loss or to prevent further infringement, you have to utilize it. And you can see that some of these pirated books, according to this case study that happened between the 14th and 17th of May 2024, was worth over 9.6 million. And then they arrested 2 suspects. Just like I said, you can also employ the mechanism of criminal litigation or prosecution. Okay. Moving forward, we also have the online enforcement mechanism. Using the online enforcement mechanism, you look at the Digital Millennium Copyright Act. It is actually a US act. However, its principles applies globally in the world, from some of these known websites like the YouTube, we have YouTube, Facebook, and all of that. So this Millennium Copyright Act, you can use its notice, a takedown notice, and tell the provider that, look, this person is infringing on my content. This person, my IP right is being infringed by this content transmitted by this website, by this, and they can take it down. I don't know if you guys know these Achalugo memes that have been trending online, from this Omonio Police movie. When the movie was put out on YouTube with the hype and all of that, some persons went to YouTube, and after some days it was taken down. Why was it taken down? There were issues of a particular studio known as Skyberry, that they used the picture of this particular studio and put it, they added it to the movie. So according to the rumors, allegedly, after even him going to meet the movie producer for a settlement, it was not, his complaint was not adhered to. So he had to write to YouTube. I know YouTube does not joke with infringement matters. It had to take it down. And after some days, the producer had to come back to give a notice that, look, my movie is back. So when it is a digital infringement, you can actually use this DMCA takedown notice or website blocking and domain seizure. You can actually use this website blocking simply means you can write and, look, my domain name is being infringed upon. The government can restrict access and all of that. Yeah. So we also have Section 25 of the Cyber Crimes Act that also penalizes anyone who intentionally takes or uses a name, a trademark, or a domain name other than the word that is being registered. And the fine is 5 million naira. So you see that in as much as Nigeria, we are still making progress with some of these laws, there are also provisions in our act that actually encourages, enforcement mechanisms for IP. Fast forward to arbitrability of IP disputes. There's always been this issue of whether IP rights are actually arbitrable or not. Okay, this is just like notice and takedown procedures litigation, just like I already explained. Please, you can move the slide. I'm trying to stay within time. Please proceed. Okay, the case before this one was just a case of the Nigerian Copyright Commission and Okechukwu. I don't know if you guys remember those days when we used to use CDs and cassettes to play. So he was actually penalized. His goods were seized for pirating some of these creators' movies and all of that. So it's just a method of, enforcing your IP right, just like I stated earlier, by seizure or probably taking down notice and all of that. So when it comes to arbitrability of IP disputes, arbitrability just refers to the determination of whether a particular dispute can be resolved through arbitration rather than litigation in courts. As we all know, arbitration is something that is taking over in Nigeria today. It's even one of the best approaches to resolve IP, especially when it's in terms of privacy, confidentiality, and particularly on agreements between the parties too. Countries like Singapore and Hong Kong, you already have an express or explicitly enacted act, to guide anything that has to do with IP enforcement mechanism through ADR. Also, for example, in Rivers State, we have like a law that actually encourages ADR, in our Rivers State multi-door courthouse. And also there are some laws in Nigeria that actually gives, privilege for some of these IP rights to actually come through the process of arbitration. However, the question is it all IP rights that can actually be arbitrable? Please move this slide. Thank you, sir. No, not all disputes, regardless of their subject matter, are deemed appropriate for arbitration, and I will explain. The concept of arbitrability in IP disputes. What it simply means is that it is not all IP rights that can actually be arbitrable, not really about the subject matter though. Certain matters, particularly those involving public policy considerations or state sovereignty, are considered non-arbitrable and must be resolved in court. There was this case then that was, back then, it was more like in the media, between Lagos State and Echo Hotels. In that particular case, the court made mention of this particular principle. He said, when it concerns issues concerning public policy or public interest, you don't bring it to court. But when it concerns issues that are private between the parties, they have the freedom to submit for arbitration. If, for example, that particular work was stated probably in a contract, just stated in a contract that where issue might arise, we have to go through the mechanism of arbitration. It is actually permissible. or where there is a law that allows for the parties to use the mechanism of arbitration, arbitration can be allowed. However, where it is matter of public interest, let's say counterfeit, the patent, just as stipulated under section 251 sub 1F, where it is matters concerning these issues as stated in that particular section, then it has to come through the process of courts. But if it is a private matter, it can actually be instituted using the procedure of arbitration. Please, sir, proceed. All right, let's look at IP disputes that are arbitrable. We see issues arising from royalties or ownership. This is because it's usually governed by contracts. Also, issues of torts like passing off or breach of tortious confidentiality and all of that. These are all within the limits of contracts. And as you all know, a trust principle in our law is that parties have this freedom to contract within the confines of the law. So where there are also infringement claims, which directly impacts only a finite number of parties, as I explained earlier, claims over unregistered rights, such as your copyrights. Copyrights can actually be protected even without being registered. Or trade secrets, especially to govern that confidentiality that comes with trade secrets and all of that. Patent and trademark infringement, some of these issues, as listed here, can actually be arbitrable. All right, please, I'll move this slide. Okay, we'll be looking at the advantages and disadvantages of using arbitration as a mechanism to enforce your IP rights. Like I said, you have confidentiality. It is just between the parties involved. There is efficiency and there is speed. There's also a streamlined resolution compared to litigation. We've seen issues of litigation where the matter will have to last over 5 years. Then what happens to your brand at that point? Do you keep going to and fro to court while your brand is suffering? That is why we have remedies like injunction to stop them, depending on whichever one that is relevant for you. In the case of Microsoft and Electrowide, the company, they had an issue. So the court actually gave them that, liberty for them to deliver up the counterfeited software back to those, to like the main owners. So when it comes to litigation, sometimes if you don't employ some remedies to forestall that infringement, sometimes you may not get what you want, to assuage your loss at that time. However, with arbitration, it is more streamlined. It is more streamlined. It's also, you have expert decision makers to, adumbrate on your matter. It's also cost effective, although sometimes arbitration can be more expensive when compared to litigation. However, on the flip side, I think most organizations, entrepreneurs, and big brands usually go for arbitration, particularly if it is a subject matter that can be arbitrated upon. We also look at the disadvantages of arbitration, enforcement issues. I know this is not, it is more like an open secret. You know that sometimes you've gotten your judgment, then how do you enforce it? Particularly when the other party is at loggerheads, they don't want to adhere to what has been already adjudicated upon, or arbitrated upon rather. Also, lack of public scrutiny. Sometimes, you need this public interest and all of that sometimes to make your case, to get what you want from a case, particularly for those who are in fundamental rights and all of that. They employ this public interest and all of that. So when it comes to arbitration, sometimes there is no public scrutiny because nobody knows what happens behind closed doors. This is another disadvantage of it. Also, a finality of decisions are final. You cannot reappeal like normal court process, where from the Federal High Court you can go to the Court of Appeal and then to the Supreme Court. We also have jurisdictional issues, just as most of our speakers already said. All right, moving forward. Please, sir, help me move this slide. All right, let's look at this case of Yahoo Inc. and Microsoft Incorporation. In this particular case, the issue was that of domain name. Under the watch of the World Intellectual Property Organization, they had to utilize the mechanism of ADR to, They had to utilize the mechanism of ADR to actually resolve this dispute between Yahoo Inc. and Microsoft regarding their domain name and trademark infringement. Please, Samu. Thank you, sir. All right. So when it comes to IP enforcement and then some of the challenges we face, you can see cases of weak and prolonged enforcement. We see cases of counterfeiting. We also see a challenge of obtaining evidence. There's always been this challenge of sometimes, especially when it is being infringed upon, how do you, how do you gather evidence to prove your case sometimes? And then the issue of globalization and jurisdictional issues. So these are some of the challenges that IP enforcement actually faces. In conclusion, therefore, IP enforcement is crucial for protecting innovation and economic growth. Nigerian legal framework provides enforcement mechanisms, but challenges like the weak enforcement and digital infringement still persist. Therefore, we as those who are in the legal profession, and we too are also studying to gather experience in this field, we can actually advocate more, try to see how we can enforce these rights. And then again, to legislative reforms, some of these acts are acts that, for example, the Trademarks Act, and apart from the Copyright Act, that is a little bit in line with current situation. Most of these acts are actually way back and do not cover the it does not cover the current issues. So legislative reforms can actually go a long way, to enable IP enforcement to become more convenient for parties. And also, it also requires judicial efficiency and stronger regulatory collaborations between some of these regulatory bodies that are involved in IP protection. So with this, I'll conclude my presentation. Thank you so much, JIIPCC, for this. Thank you so much for this opportunity. I really appreciate it. Thank you so much. Thank you to our mentors too.
All right, thank you so much, Fortune. Well done for putting together or making presentation on behalf of your group. I think it was a very interesting presentation you put up, and we say well done once again to you and your group. So please, we'll be going back to group one. Please, group one, if you're ready, we would like to take the presentation now. Okay, thank you.
Okay, good evening, everybody.
Yeah, good evening, Farida.
Okay, good evening. Thank you to our mentors for sharing such a wonderful lesson to us. We really appreciate it. So I'll be taking IP registration and infringement today. Please share the second slide. So IP registration refers to the process of creators gaining exclusive rights for their creations. That is, they have legal rights to execute their inventions, literary work, their symbols, their names, their designs. It also helps the creators from creations from unauthorized use from other people, and it ensures that the creators gain benefits from their own creations. The creations are patents, trademark, copyright. So we have different registration processes. We have the national, we have the regional, we have the international. For the national, that is in the aspect of countries. Each country has their own registration system and their own agencies that is in charge of the facilitating such registration. So for Nigeria, we have NCC, the Nigerian Copyright Commission. They are in charge of literary and artistic work. We have trademark, patent and design regulations. We have NIPO. So the registration processes for national, I think we have about five. So the first one, they are to submit the applications. The creators are to submit the applications they are to submit it to maybe like the NCC, the trademark and patent design regulations. So after submitting, okay, here we have the United States Patent and Regulation Office, the Intellectual Property Office. So after they submit it, the officials, they assess the applications, they review it, they check for originality, they check for maybe mistakes, and they check it, they review it. So then they publish it. They publish it's not in every aspect that they publish it, because it is only like, I think, patents and trademarks that are needed to be published to the public for like objections or oppositions from third parties. So when they are published, if there are no objections, then they are approved and the exclusive rights are granted to the applicant. So and for that's all for some IP, for some intellectual property. But in the case of patents and trademark, they do need renewal and maintenance. For I think for trademark, they are to be renewed for up to 20 years. I'm sorry, for patents, they are to be renewed for up to 20 years, while trademark is to be renewed after 10 years. That is in the case of national registration process. Then we have the regional registration process. So this one, it allows for creators at regional level to protect their creations, their inventions, their trademarks across multiple countries within the same within a specific geographical location. It simplifies the process of unified registration mechanism, instead of like applying to separate applications in each country. So once you register under regional, you can access countries under that region. We have in the case of ARIPO, that is African Regional Intellectual Property Organization. So this one, it manages patents and trademark designs, trademark and industrial designs for member African countries. We have OAPI, that is Organization African Property Intellectual. So this one is for IP registration for French-speaking African countries. We also have European patent offices. It grants patents valid in multiple European countries. So we have the registration process. It's similar to that of national registration process. The applicants are to file their application. After they filed it, the officials will review it, they will examine it. Then in the case of trademark and patents, they publish it out to the public to allow third parties to raise objections. And then if there are no objections, they approve it and the rights are granted. Sorry. And then for some IP rights, they require periodic renewal in the case of trademark and patents. Then we move to international registration process. This one, it provides registration at international level. So instead of filing separate application in each country, once you file a single application and it is approved, it is recognized across multiple jurisdictions. Your business, it protects their business, it protects their creations, their trademark, their patents. So we have different systems. We have the Patent Cooperation Treaty. This one is registered. It is administered through the World Intellectual Property Organization. So once they file their patents, it is recognized in over 150 countries. Then we have the Madrid system. It enables business to register trademark in multiple countries. We have the Hague system of industrial design. We have the Berne Convention for copyright. It ensures creative rights are automatically protected in member countries without registration. Then we have the process. So the process is a little bit different from that of regional and national, because the applicants here submit their application through their designated national or regional office, in this case, WIPO. In this case, WIPO, and after they've submitted it, the applications are checked, they are reviewed. Then, just like in the case of national and regional, just like in the case of regional and national, they are published. Trademarks and patents, they are published in case of objections. Then, if no objections are raised, then they are approved. And some IP rights are still subjected to renewal and maintenance. That's in the case of patents and trademark. And for patents is up to 20 years and trademark is after 10 years. Then we have the challenges. In the case of IP registration, it is usually the registration is usually very expensive. That if a creator is not financially capable, he will not be able to afford it. And in the case of national and regional, we have different IP laws across countries. So there is law barrier, there's legal barrier, and in some countries we have weak IP right enforcement. That even though you have like a copyright for your book, it is not really enforced. There is weak enforcement and people are taking advantage of that. So the rise in digital countries, it makes it hard for them to track online fraudulent activities because there are several different apps, there are several different sites. It's very difficult to say to know which one, to track the track people that are infringing your copyright, your IP rights. So now we move to intellectual property infringement. So this one, it refers to the unauthorized use, reproduction, and distribution of someone else's creations. We have their literary work, their artistic expressions, their inventions. It violates the rights of the owners and it leads to legal consequences. It leads to a lot of consequences because number one, it reduces the revenue for the creator, and then it's just like I think Mr. Max said, it spoils the image of the company. So they've made laws to prevent such. We have the Copyright Act 2022. This one is protecting literary creative work like music, books. We have the Trademark Act, the Patent and Design Act. So we have two types of infringement. We have the physical and we have the online infringement. The physical involves unauthorized production or sale or distribution of tangible goods that violate IP laws. This one includes reproduction of fake products, like they make a fake version of maybe branded products, pirated goods, pirated media. They reproduce books, CDs, DVDs without the original creator's permission. And then patent violation. This one is where they create imitation. They create an imitation of the creator's invention without his legal rights. So it affects the business of the creator. They lose revenue, they face damages, and governments have started enforcing anti-counterfeiting laws and to prevent such. Then we move to online infringement. So online infringement is they include data piracy, software cracking and hacking, plagiarism, content theft, use of brand name or logo. This one is rampant, very, very rampant these days. In the case of online infringement, I think that is we have if those are read, they would know the library. they took it down, and I think they brought it up because number one, they allow us to have access to different authors' books. We are not paying for it, so it's pirated. So I think they got to them and they took it down. So that's in the case of online infringement. I think in Kiri too, Net Nigeria, they stopped Net Nigeria. So those ones are online infringement. Then we have piracy. This one is oh, sorry. Before we get to piracy, Data Protection Act 2023 has been enacted to regulate data protection. It has been enacted in Nigeria to protect data of or maybe authors or creators from such piracy. Then we move to piracy. This one is there are serious threats to intellectual property rights. They affect businesses, they affect the consumers, in fact, they affect the economy. They are the illegal copying and distribution of copyright materials like books, music, movies, without the knowledge or the legal rights of the creator itself. So we have the case of then anti counterfeiting. It refers to the measures and the activities designed to reduce the sale of counterfeit or um pirated pirated goods. In the case of like maybe um of unauthorized use of the creator's invention, trademark, or his artistic work. So one of the case of physical anti-counterfeiting case is the Louis Vuitton use of RFID tag. So here, Louis Vuitton, they found out that a large scale of their products is being like dubbed or reproduced without their knowledge. So they came up with an idea to use RFID. This one refers to radio frequency identification tag. So they put the chip in the product. So it has very unique digital signature that allows the consumers and retailers to verify the authenticity without using scanning devices. So once I heard of a recent case, I can't remember. I think in the case of Regina, that our brother bought that she posted a Rolex, yes, and people were saying that it is fake. If she wanted to prove them, I feel like she should have just taken it to maybe the original store, and then there they would verify whether it's an original Rolex or not. So that wasn't like what Louis Vuitton did. So they made a unique chip that once you want to verify that is this real, you take it to a retailer, and then once they scan it and it brings out the unique digital signatures, this digital signature it will show that this is an original, and even the case it does not have that one, you would know that it's a counterfeit. So it reduces counterfeiting and it allows for better supply chain tracking and authentication. Then we also have in the case of pharmaceutical industrial serialization, that is Jiipcc. This the use of serialization, they would use unique serial numbers on the product, or they use the barcode, or they use RFID so on the product. So when it gets to the consumers or the pharmacists, they can verify the authenticity through via database. Service. So if you buy a drug, okay, I think if you buy all these malaria drugs, they will put the stickers there and they will ask you to scratch it. If you scratch it, they will ask you to type the code.
Hello Farida, we can't really hear you anymore. Your network is breaking, and if you can, please, can you also try to wrap up your presentation as quick as possible? Okay, please, can anyone hear me?
Yes, I can hear you.
Okay, it seems we lost our presenter. All right. I think she was almost done with the slides when she went off, right? So I think we'll just be moving so that we do not waste time. We've already spent all our time, taking presentations, hearing from our mentors.
Hello.
Can you hear?
Yes, I can.
Yeah. So please, can you
Hello.
just quickly tie up your presentation
Yes,
so that we?
Yes, I'm almost done.
All right. Please quickly do that.
Okay, so I think I was talking about the Red Bull, right? So I saw a recent advertisement of where they changed their bag of rice and they added a unique hologram to it, and they were warning consumers that once they don't see that hologram on the rice, they
Farida, your network seems to be very bad. I don't know exactly why, but we seem to be losing you on the presentation. So sorry, we will not want to continue like with the whole process of just waiting for you to get back on. So we will just be moving over to feedbacks from the mentors. So sorry we had to cut you short like that. Thank you so much, Mr. Akinwale, for helping us share slides. Well done to you and to your team, and also to Farida for presenting on behalf of the group. I think we still have our mentors in session. Yes, so please, we'll just be taking quick feedback from them, and then we'll be addressing questions, and then we'll call it a day. We're already fast spent on our time. So over to Mr. Max once more. Mr. Max, please, we would just like to get a quick feedback from you on, the topic of today. If you have any feedback you would like to share with our mentees.
Okay, thank you very much. So first of all, let me commend both groups for the groups for the presentations. It's always good, to hear these presentations. For me, what it does for me beyond anything else is it just shows, the level of effort the mentees are putting on. But also what I notice, having been in Jiipcc for a while, is that I see how week on week there's progression in the depth of the presentation skills, the research, and all done by the group. So I want to commend both groups. I particularly commend, I believe, was group 2 that spoke about arbitration. That's actually a very important issue, and it's still, in fact, lately, a very experienced arbitrator contacted me to ask me questions because he's having an arbitration where some IP issues have arisen, and it's a little uneasy and confused. So the issue of the arbitrability of IP disputes has a wide range of arguments, some very extremist arguments, some moderate arguments, and some quite realistic arguments. I particularly commend the group because they able to take their time to really break down the distinctions, which is what a lot of people are not able to understand. Of course, the Nigerian situation is complicated because the very extremist argument initially was that all arbitration disputes are not arbitrable. And the proponents of that school of thought argue that because intellectual property matters fall within the exclusive legislative list, therefore they are within the exclusive jurisdiction of the Federal High Court, and an arbitration tribunal cannot handle them. They make this argument because there's some really funny judgments, particularly of the Court of Appeal, that said tax matters are not arbitrable because they are matters in the exclusive legislative list. However, there's a judgment of the Court of Appeal that now clarified that the reason why tax disputes are not arbitrable is not necessarily because of the exclusive jurisdiction of the Federal High Court, but because the tax laws have a regime of how to dispute tax computation matters, and then you go on to a special tribunal called the Tax Appeal Tribunal. So that's why tax disputes are not arbitrable. However, in that same judgment, the court now explained that, however, where the tax dispute arises from a contractual dispute, so it's a matter of, a breach of contract and all of that, and the tax dispute is only ancillary. It's not that the people are contesting the actual tax computation. They are simply saying that we have a dispute. You are owing me some money, and you are supposed to pay the tax on that money. We are not arguing as to how much is being owed for tax. We are not going into computing or the tax liability. Those issues are matters for the tax appeal tribunal and all of that. We are simply saying, because you are owing me money, set off what you are owing me against the tax liability you should pay on my behalf. That in those cases, when it's just a contractual matter and the tax matter is secondary, then the arbitration it can be arbitrable. So using that same analogy, we can also say the same thing also for IP disputes, that when the core dispute, and typically we need to note that usually an IP dispute will not go to arbitration normally. The reason is simple. For a dispute to go to arbitration, the parties must have had a contract, an arbitration agreement beforehand. But in a pure IP dispute matter, an infringement matter, it will be crazy for any infringer to come and sign an agreement before infringes on your goods. Usually the infringer is a third party you do not know at all. So the dispute arises outside of the bandwidth of an arbitration because there's no agreement between you and the infringer beforehand to resolve your dispute by through arbitration. So more often than not, arbitration won't come in that way. So arbitration usually come in from contractual disputes like franchise agreements, where there's not a dispute between the franchisor and the franchise. Maybe the dispute could have been that I gave you I gave you a franchise, you have gone to use my franchise in a way that is not compliant with the franchise Bible in terms of maybe you have introduced other menus, say fast food restaurant, you have introduced other menus and other processes into the fast food outlet that are not in compliance with the franchise agreement. So you can see that in that case, this is a contractual dispute. The issue of whether the person misused the trademark and all that is only secondary to it. However, if the claim involves, and the group 2 made that point, which is also very important, if the claim involves the validity of an IP right, for instance, whether the patent is valid, then that becomes a matter that cannot be arbitrated. You have to go through the channel created in the law. Similar also to something like patent, because we need to understand that a patent is a monopoly granted by the government to an inventor. So the government wants to keep that monopoly is granted, it's sort of a national interest issue. So you cannot arbitrate that. If the dispute now centers on whether the patent is valid or not, or whether the action of one of the parties infringes that patent right or that trademark right, then in those cases you cannot arbitrate. So you can see it's not a question that it has a yes or no answer, but I love the way the group was able to break it down to show the factors that would indicate. Some countries, have gone to the other extreme where they allow arbitration to any possible level of any IP dispute. Some countries have a middle ground where they say the arbitration panel can actually even pass an award even on issues like infringement and validity. But the difference is that decision of the arbitration tribunal is only binding on those parties. So therefore, the arbitration tribunal cannot nullify, for instance, a patent grant. It can say, as between these two parties, this patent is null and void. But the patent granted by the government still remains valid for other people. But between those two parties to that contract that went to that arbitration, it can be nullified. So it's a middle ground that some countries have had, and I think that actually is the best middle ground to say, look, if parties have reached an arbitration agreement, let it be respected, irrespective of the fact that the underlying subject matter is IP rights, and that some of the decisions of the arbitration tribunal would actually go to the national interest elements of that IP right, provided that the decision of the arbitration tribunal is only restricted to the parties to that arbitration and does not bind the whole. But of course, if you had gone to a court and a court nullifies a patent, that patent becomes nullified for the whole world. It means that patent becomes invalid and will not have applicability even outside of the transaction between those two parties. So those will just be my few comments. And then again, I end by commending all the groups for the presentations. Thank you.
Thank you so much, Mr. Max, for that feedback from you. I really do appreciate the insights you shared. So we'll be moving over to Ms. Rita for her feedback. Please, Ma, do you have any feedback for our mentees on the presentation they made as regards the topic for today?
Okay, beginning once again. I'm not sure I have much to say, but just to say kudos to the teams that presented. And just like Max, I actually did enjoy the arbitration presentation because that's one of the areas I practice in. And I would like to align my thoughts with everything that Max said. But just to conclude that from this presentation, it also gives participants insiders view as to the opportunities available to you in the IP space. And just like the case that Mark stated that he was being consulted for, you can be consulted for IP related issues. You also need to think bigger in terms of other common form of IP like TCEs, cultural heritage. How can those disputes be resolved? Well, yeah, that's about it. For the registration, I would say kudos to the team that represented, even though they had like bad interviews. I think they did their best in terms of highlighting the procedure for registration from the national level down to the international level. And that's the work you're doing. Not knowledge is a risk because it can come in handy someday in the future. So I'll just stop there. Thank you.
All right, thank you very much, Ma. Mr. Sand. Yes, sir. Please, we still also want to hear from you. Any feedbacks before we take questions?
Okay, so I think basically Max has really elaborated on it giving a detailed feedback, especially in the aspect of arbitration. And Rita also align my thought with Rita's position. My own is just to commend the team. I've also seen that week in, week out. I think this is the season that I've been a little bit, even while I've also been on the road, but listening in on the mentees presentation. I kind of like the presentation because it strikes the balance of theoretical explanation and the reality of IP. I like that aspect of, especially like group 2, sharing the aspect of the NAFDAC practical experience of the danger of IP infringement or theft, if I may use that word, of other people's hard work. Because what we, I think is a criminal act and an evil agenda of going into the pharmaceutical world to counterfeit an already existing brand. I like that. I like that aspect, and I also like that. I think Group 1 also brought in a case study of Louis Vuitton and Alibaba. That speaks to the reality that IP is not an abstract thing. It is about the reality of businesses, and it is about reality of life. I also like that aspect where, in terms of, I think it was Group 1 that brought in practical measures in how to fight the issue of counterfeiting. They said you use RIFID, RIFID, this chip. But these are for big brand. I want to see more of them speaking more, because as I said earlier on, my interest in terms of the economic part of this, and in our society, we have 90% of small businesses thriving and creating opportunity, and as well as running as part of SMEs are called the engine of economic growth, especially in developing countries and in a context, Nigeria and Africa. I want to see them use those small businesses as an example going forward. Maybe for next week or next week's, let them identify small businesses that are struggling and how they can apply that. We want to see a little bit, there's a lot of text, knowing fully well that the presenters and as well as most people in the room are legal people and as well as academia. So if we can see a little bit of visuals, not go and use AI all through, like last week's people group use minimum of that, because we are talking about IP, so we have to still practicalize this. Use a little bit of visuals, I don't know if the school allows a video to explain their thoughts. But if it is, maybe they can get some and also speak to that, because you use different mode of teaching to drive home your point, so people can read and absorb, some can watch and absorb. So you take care of all this, for especially I know everybody here, no one is less than 18, so we're all adults, so we learn at different level like that. I want to see that. But above all, there is this consciousness and ability to go in and do research and come to present. I commend you guys for that. Well done. Just keep it up. And this shows that the future before now, so they have the opportunity, the future of IP is sure, and if the country have men and women that will take over some level of leadership and deliver at it. Well done, colleagues. Group 1, Group 2, you guys did very well. Well done. Thank you.
Thank you so much, Mr. Sand, for that wonderful feedback. All right, so please, we'll be taking live questions, right? So we'll take a few. We're already like way short on our time. So what we'll do is that we'll take, I think, about 3 live questions, get our mentors to answer, and then, we'll call it a day. Okay, I can see 3 people raising their hands already. So we'll just take those 3 questions and, we'll call it a night. So let's start with God's favor. Please, you can go ahead, unmute, and then ask your question.
All right. Good evening, everyone. Good evening to the mentors and all our speakers. So my question is firstly, as regards arbitration. So I want to ask, of course, there are some cases whereby contracts will contain arbitration clauses. However, in the absence of that, is there usually a requirement of mutual consent between the parties before arbitration can be possible? So if one party is urging for arbitration and the other is not disposed to it, can arbitration still be workable in that context? And as regards my second question, which is the last as well, I want to know where the line is drawn as regards infringement of copyright. Yes, I understand that there are some actions that are clearly violation of not only copyright or other IP rights. However, in some context, like in the example, I've forgotten who the speaker was. He gave the example of, let's say, okay, I think it was Mr. Sand. He gave the example of songs, right? Whereby a singer releases a song and subsequently in church the song is used. So it's not usual to see cases whereby, for instance, singers, even on global stages, use the songs of others. So does that not amount to a little bit of infringement of copyright? Another example is in the case of books. I know that in the beginning part of books, you see statement or clauses such as no part of this book will be produced, shared, or something like that. Sure. However, still, as regards those books, you will see cases whereby pages of those books are copied. Of course, with reference to the book. However, the clause at the initial or the introductory part of the book expressly stated that it shall not, such sharing or such reproduction or transmission shall not be done without express writing and express consent of the author in writing. However, in these cases, the author did not give his consent. However, the book is referenced. I don't know if you get the point. So, does that not amount to infringement of copyright? Those are my two questions.
Okay, do you want me to take that question immediately before we take the next question, or do we take all the questions first? Okay, can you hear me? Sorry, just to confirm.
Yes, I can hear you. I think the question was directed at Mr. Dennis.
Okay, so I believe the first part of arbitration was directed to me, right?
Yes, sir. Yes, sir.
Okay. Yeah, so on the arbitration, yes, you ask a good question now. So what we must understand is that arbitration, one of the fundamentals of arbitration is that arbitration is a consensual process, just like any other ADR. Consensual means that the parties must agree for it to be able to happen. Unlike litigation, litigation is not a consensual process. That means when I go to court and I sue you, I don't need your permission to sue you. I'm commanding you to come to court and answer my claims. But in arbitration or any other ADR, alternative resolution, is consensual. That means parties must agree. But parties can agree in two ways. So the arbitration can be based on two documents. Either what we call an arbitration agreement, which is an agreement that is signed before a dispute arises and says, if any dispute arises, we'll go to arbitration. Usually it is contained as a clause in the body of an agreement. We say that parties hereby agree that any dispute arising from this contract will be submitted to arbitration and all of that. So that is what we call an arbitration agreement. It's an agreement made at the time of transaction, agreeing that in the future, if any dispute comes, we'll go to arbitration. But another way you can go to arbitration is that a dispute has already arisen. Both of you can now agree that rather than go to court, let's go to arbitration. You now do what we call a submission agreement. So at that point, the dispute has already arisen. You are now agreeing to submit to arbitration, and then you agree. So those are the two things. But the bottom line is that the jurisdiction and the power of an arbitral tribunal comes from the consent of the parties. So if one party says, I don't want to go to arbitration, arbitration cannot happen. So that's just to make that clear that, and like I said, usually for an infringer, it's usually not a reasonable person who is going to agree to go to arbitration with you. But like I said, typically most other IP matters that are contractual, you should, like in a franchise agreement, in a trademark license agreement, I'll just typically an arbitration or even mediation. So note that there's also options apart from arbitration. There's also mediation. So the difference between arbitration and mediation is that arbitration is a party. It's a dispute resolution process where a third party sits just like a judge and gives a final verdict that is binding on the parties. That means the arbitrator is appointed by the parties, but he doesn't, that the decision he's going to make is a decision that is binding on the parties. But in mediation, parties come together and appoint a third party who helps them to find a settlement. So at the end of an arbitration, you get an award, which is binding on both parties. But in mediation, at the end, you get a settlement agreement, which is that parties agree that this is how we want to settle this dispute. So without the agreement of both parties, you can't have finality to a mediation. But in an arbitration, you only need the agreement of the parties to start the process. You don't need the agreement to enter a final award. But in mediation, you need the agreement to reach a settlement. So mediation is sort of like negotiation essentially, but just that the third party is a neutral, properly trained person who helps you guys to find that solution. So it's just an enhanced form of negotiation. So I hope that answers your question. At least the first leg. The second leg, I didn't get it too well, but I suspect one of the other mentors, maybe if Rita is here, if she got it, I'm sure she'll be able to take that.
All right, thank you, Mr. Max,
Sorry.
for helping.
Max, what did this say I should take? Please, I'm so sorry. What did this say I should take?
Second leg to the question. I don't know.
Okay. I think it was who asked the first favor. What was the second part of your question, please?
He was saying about infringement. Maybe if you repeat that question, even myself, I didn't really get it properly.
Yeah, God's favor. Please, if you are with us, please can you repeat the second part of your question?
Yes, sir. So, yeah, thank you so much for the first answer. It actually answered the question. As regards the second, I asked that, where is the line drawn as regards infringement of copyright as well as other IP rights, but especially copyright? Because there's, okay, and one of the speakers gave an example of a songwriter, let's say a musician that releases a song, and subsequently such songs are used in on live platforms like presentation in churches and all. I'm asking that does that not amount to infringement of copyright to some extent? And also,
Sorry.
in the case,
Carry on.
yes, ma'am.
Please carry on. Carry on.
So the second example I was going to give was as regards books. So in some books, you see them a clause at the initial part of the book stating that no part of the book shall be transmitted, shared, or something of that like without the consent of the writer
Okay, so
expressly.
let me just answer. What's the thin line between an infringement? I would say, I think so if you look at the definition of what IP is from WIPO, it states that IP includes literary words, invention, etc. that must be used in commerce. So when a work is being infringed, you have to look at the fact of whether it was commercialized or it was not commercialized. If it was commercialized, then the person has executed the exclusive right that has been granted to you by the law, and he's not supposed to do that because consent, permission, and authorization is very important when it comes to the use of IP. If in the event that the person did not make profit or did not use it for commercial purpose, then the provisions or the principle of the fair dealing in Nigeria and fair use in the US would apply. Was it for private use, research purpose, news reporting, whatever the situation is. However, there are other exceptions or limitations such as getting compulsory license from NCC in events where you want to reproduce or republish a work. You need their consent for that. I think I can't remember the section number. It's one of the sections, 22 something. Then you also have the exceptions for people with disability under Section 26, whereby those are people that are allowed to use copyrighted work without actually getting express consent from the author. But however, the beneficiaries or the entity who gets to get the consent has to reach out to, I think, entity for that. Then I do recall when I was making my presentation, just to answer your second part, where I talked about alternative to copyright schemes, where you have things like Creative Commons license. There are about 6 types of Creative Commons license that come with their own terms, whereby some of these CC license will require you to use the work but give up to acknowledge it. So require you to use the work, acknowledge, and also do not use it for commercial purpose. Some will say acknowledge acknowledge the author. You can also put in adaptations and all of those things. So if for instance, in a book, not a book, I think most WIPO publication has that CC license included in it, where it's written that you can use the work for research people, but you're not allowed to share. So if someone has put out that notice to say you can use the work, but you cannot commercialize it, you can't commercialize it. In the event where you want to use it for more something outside the fair use or fair dealing process, here's an email. I think there was a publication I saw last week, and I think I also shared that with my students in school, where the school publication stated that can't share without informing them, or you can't use it or adapt it or whatever, reproduce it without actually informing them. There was an email attached to that notice. So you cannot claim not to be aware of such provisions. Then if you look at the provisions of, I think it's section 51, where it talks about how someone at the Convention of Technological Protection Measures, if someone has taken the extra, especially for literary work, if someone has taken the pains of actually putting in encryptions or passwords that in order for you to access that work, you have to reach out to them, and then you bypass that, and then you go ahead to use it, you're liable for an infringement. Then you also consider rights management information, whereby you intentionally remove information belonging to an author and then probably not even acknowledging that the person is the owner of that work. So I don't know if that answers your question, but if it doesn't, you can always send your questions back to Jerry. the JIPCC, and then we can always rehash. I also have a podcast for the IP series. You can also, I think I have about 136 episodes so far, so you can listen to any of them that answers your question.
All right. Thank you very much, Ms. Risa, for helping us with that question. So we'll be taking two more questions, and like I said, we'll call it a night. So I think let's start with Paul. I can see your hand up. Please unmute and ask your question.
All right, thank you very much, Sir Williams. Good evening, everyone. Good evening, our mentors. Thank you very much for tonight's mentorship. I've learned so much. So very quickly, my question is this. Is commercialization the only way in which IP can be infringed upon? I ask this because our first speaker, Mr. Max, when he was speaking, he mentioned that two things are observable from, well, okay, two disadvantages are observable to someone whose IP has been infringed upon. One is that the value of the brand is devalued, and secondly, the benefit which would otherwise would have been accrued to the owner is lost. So is commercialization the only way in which IP can be infringed upon?
All right, thank you, Mr. Paul. Mr. Max, I think the question is based off of a point you raised in class, so I don't know if you have an answer for that question, sir.
Okay, yeah, thank you. Yeah, so thanks, Paul, for that. That's a good question. So no, so infringement actually can take very many different shapes. Of course, commercialization is the easiest, but like I mentioned, also there's the level. There's also the part of tarnishment. There's also the part of free riding, where a person is not necessarily in the sense directly commercializing, using commercial purposes to extract the value of your, of your IP. But he's using free riding, he's using a comparative advertisement, which is also another type of infringement where a person is, doing an advert for himself and saying something like the advantage of maybe he's now doing a comparative advantage and saying my own bottled water has this and this, or the other brands in the market don't have it. And then he puts a picture of your own bottled water next to his own bottled water and he's trying to show advantages that his has and yours does not have. Now, so he's not directly commercializing, he's not selling your product, he's not counterfeiting your product, but he's running you down in the market. So that becomes a type of infringement that is also covered under the Federal Competition and Consumer Protection Act, comparative advertisement. So, however, comparative advertisement has certain nuances. So, for instance, there are exceptions that says that people, for legitimate purposes, can use your IP without being an infringement. So, an example is if I repair BMW cars, then automatically I have the right to use BMW trademark in my advertisement. That would be a legitimate use because I'm saying, look, I repair BMW cars, so I can put the logo of BMW on my, my website to show that I repair BMW cars. It's still a very tricky area. So there's what we call the right to repair, which is a major debate going on all over the world now. So if you notice, for instance, a time came now, almost any phone you have now, you can't open the batteries. The batteries are sealed. So it's because manufacturers now know that they want to make money on selling devices and also make money on after-sale services and repairs. So because of that, they now restrict the ability of users to repair products themselves without going back to the manufacturers. And when you go to the manufacturers, they now charge exorbitantly. Something as simple as swapping out a battery. You go to an Apple store and they charge you an arm and a leg. Something that any other person could do. So some countries like the EU have mandated that you can no longer do sealed batteries in laptops and in devices to ensure that people have the right to repair them themselves. So it's a huge argument that falls out of this issue of comparative. So in those some of those places now, like in some of those countries, the manufacturers actually try to restrict repairers and sue repairers who put up an advert using their trademark to say, look, I repair, say, Apple phones, for instance. So you see Apple writing a cease and desist and saying cease and desist from doing that. So it's still a thorny argument, but yes, there are so many other ways to infringe without actual commercialization and without it being a out-and-out case of an infringer simply trying to counterfeit your product. So even by associating your brand with things that you do not want to. So for instance, somebody now, maybe you run a hotel chain and somebody's using your hotel chain name to promote pornographic movies and all of that. That is, he's not necessarily saying he's selling your product, but he's using the name
Hello, Mr. Max. Are you with us?
Yes,
I
got
think
me. Oh, did you lose the last part of my answers? Apologies.
you lost the last part.
Okay. So I ended it just by saying that, it could also be by tarnishment, where somebody's associating your brand with with a line of products that you are not necessarily competing with, but that essentially is rubbing off your own brand in a negative way. So you have a hotel chain, for instance, and somebody's using your hotel chain to sell pornographic videos and all that online. So it's using the popularity of your brand to sell its own products. But even though he's not competing with you, but essentially it's now beginning to associate your brand with an undesirable attribute. So that also can be another way that the person is infringing without directly commercializing. So those are things you have to watch out for essentially and protect your brand against. Thank you.
All right,
Thank you so much.
Thank you very much.
Thank you very much. Thank you also, Paul, for asking. So our final question is going to be from Fortune. Fortune, please, you can go ahead and ask your question.
All right. Good evening, everybody. Thank you to the mentors. My question is on behalf of Group 2. So we've looked at the different mechanisms for IP enforcement. So now we just want to ask our mentors to give us some practical steps that small startups or small business enterprises with limited resources can actually utilize to protect their IP rights.
Okay. Thank you so much, Fortune. If Mr. Sand is still with us, please, I would like for you to maybe help with that question, sir.
Okay, so thank you very much, Max, for those detailed response. One can actually go home and just, I'm not encouraging any mentee to do that, to just go home after listening to Max and start calling himself that I'm an expert, I can handle anything that has to do with IP consultancy service. I'm not encouraging you to do that, but I think you should listen more to as more about to all the mentees. Me, I'm only focusing on where the money is, and so you can consult me on that. So now, for small businesses, I think I did mention during my presentation that one of the things that I'm hoping that business membership organization will start doing, especially in Nigeria, is to start supporting SMEs and supporting them in real time, not about someone, even MBA, to start having a session where they offer these pro bono services for small businesses to fight and protect their IP right. Because most businesses pay, if it's in the US, an average patent enforcement costs you about $300,000, and they'll give you time. It will take 2 years. And IP lawyers there don't smile. They charge per hour. Even just this class we're having is an expensive class in another clan, and that's why you just have to take it serious. So one of the ways small businesses can use to be able to fight infringement or enforce their rights when it's being abused or when someone steals it is through their business membership association. I think that's one way they're not doing it. I don't know why, or maybe they don't understand the magnitude of what IP is to a business that is just starting up. One other way to engage this is for one to not really meeting a consultant, but maybe have an issue, have the line dotted, and have a simple template for agreement, who uses what and who does not use what when it comes to your business. So it's not that you are being conscious about that agreement from day one with whoever, and you put it out there for people to know. I think thirdly is to have maybe people like Max or people like you for them to advise early. I think that is what I can think for now, except other mentors have. But for me, I think the best way for a small business to really protect their IP and enforce it is through belonging to a business membership association. I think it's one of the fundamental areas where they can address it. They're not doing it, But if you are a member of a chamber of commerce, we can press it on them to start considering that aspect. That is what I can think and consider for now. Thank you.
All right, thank you so much, Mr. Sand, for helping us with that question. So far, so good. We've had a very, very interesting discourse today. We've spent quite a lot of time, discussing IP registration, infringements, and enforcement. And a big thank you to all our four mentors today in class, with also Mr. Polarin in Essential at the moment, for helping us run through such a very wide or vast area and covering it in 2 hours plus. We say a big thank you for enlightening us and making us better within the space of IP. And I think with that, it's safe to say, to call it a night. Thank you to also our mentees for staying till the end. Thank you to the group presenters for presenting, and also thank you to those who asked questions. Please, let's do well to, start making practice out of the things we are learning. Share what you've learned. With that, you get to better, retain, what you've learned, and you just overall draw people's attention to these subject matters that relate to IP. So please, I encourage you to post what you've learned, share the link with us, and we'll do well to also push it from our end. All right. It's been a wonderful time in class. Once again, a big thank you to our mentors. We wish you all a wonderful night's rest. Okay, yeah, before we go, I forgot we're supposed to take a quick screenshot of today's class. So please, for those who have, lighting in their background, please kindly do well to turn on your video so that we'll take a quick screenshot and then we'll just call it a night. Okay, thank you, Mr. Akinwale. Do we still have more mentees that can turn on their videos? Let's take a quick screenshot and be out of class. All right, I can see more people. Please, can we have more people turn on their videos? Thank you very much as you comply. All right, that's fine. So we are done for today. Please, everyone, enjoy the rest of your evening and have a wonderful night's rest. Please do not forget to fill in the attendance list for those who are in class. Yeah, we will be looking at it, and we'll be paying attention to your attendance. So good night, everyone, and have a wonderful night's rest.
Good night. Bye, guys.